Good morning, everyone, and welcome to another episode of North Alabama Law Review. I'm your host, Shauna Hill. Today we have joining us Mr. Bennett Driggers and Mr. Russ Howison. Good morning, guys.
Good morning.
So today we're going to talk about a topic of debt. We all know after the holidays we have those credit card bills rolling in, possibly some medical bills that we put off to be able to celebrate, and that can really affect us, and especially if it goes to collections. So today we're going to talk about the difference on how to handle those debts and the difference between collections versus bankruptcy. And guys, and Russ, bankruptcy is near and dear to you. You've been doing it for a while, so I know you have some great insight to give us, as you've done on a prior episode before. But can you help us break down exactly what goes into debt collections and the rights that our consumers have, and then also dealing with bankruptcy as well?
Absolutely. For a lot of years before doing bankruptcy, I did collections work and collections defense work. So seeing a lot of this play out in the courtrooms, I've seen a lot of people ask questions about what they need to do with their debt, and I get a lot of questions still to this day about which is cheaper. Is it cheaper to hire you to fight the debt collection or just file a bankruptcy? And to be quite honest, with an hourly rate, you're probably going to exceed the cost of bankruptcy to fight a debt collection case. The problem is whether or not you have other debts behind that one that we need to deal with. If we're dealing with more than one, it might be in your best interest to actually deal with that one through bankruptcy because you have more coming. So we have a whole lot of fight that we can put into a case, but if we get that one settled, if you've got more coming, we might need to look at a bankruptcy, because a bankruptcy is kind of the nuke. It goes off and takes care of all of your debt. If you just have one, if we're just dealing with one case, it might wind up being in your best interest, because even if you wind up with a judgment against you and we work something out on that one, that's not going to hit your credit as bad as a bankruptcy would. So we have a lot of different pieces of information that we want to gather from a person with regard to their finances, their employment, their assets, things that might be exempt from collections, because you do have certain portions of your income, certain types of income, and certain types of assets that are protected under Alabama law that we would need to take a look at to see which one might work better for them.
One thing I would caution, if I can jump in here.
Sure.
There are a lot of services out there that claim to be able to consolidate your debt, get you out of debt. And you'll hear a lot of advertisement this time of year, because the creditors know that, hey, holidays just came, people overspent, like they tend to do. So be careful, because some of those make promises to consolidate, and you make a payment to them, and then a year down the line, you're finding out that those payments didn't go forward to your creditors. Yeah. And you've just lost all that money on top of what, you could have used that to pay down some of your debt. So be very cautious. There's a lot of fraud going on these days. They make these services and things they provide or claim to provide look real, and just be careful. There's no easy fix when you get in debt. So if it sounds too good to be true, it is. Be very cautious with those types of things, because there's a lot of other ways that people offer, hey, I can get you out of debt, we can do this, we can do that. Of course, they're in it to make money, so some of these services are legit, but it's hard to tell which ones, so be very cautious. When in doubt, don't, because you're risking paying money into them thinking that these debts are being paid for, and I know I'm repeating myself here, and they're not. And they've made no arrangements with the credit card companies or with whoever to get this debt reduced or anything. They're just made arrangements to make a payment to them, and then lo and behold, your interest rates and all your debt's going nowhere. It's still the same or worse than it was when you took on this service. So be careful with that kind of stuff, especially this time of year, because there are people are lurking out there to frankly take advantage of folks who are struggling. So don't fall into those traps.
Well, let's go back to the beginning when it comes to debt and bankruptcy. So when you essentially have your unpaid bills and they send it to collection, what exactly are the process that the collectors have to follow? And we all know we get those annoying phone calls a day. If you have a collector, they call multiple times a day. Some of them spam, some of it is legit. But how should one handle it when it comes to being turned over to a collection company is calling? What should our consumers and clients look out for and handle that?
A lot of creditors will not keep debt in-house for collection purposes for very long. If they keep them for 30, 60, 90 days to work with you and talk to you about the debt, that's great. Work with them as long as you can. If it gets sent to a debt collector, what you're typically dealing with is either a collection agency that doesn't own the debt and has to go back and check with the original creditor before they can do anything anyway, or they're a debt buyer. In either case, you are not talking to the person who may own that debt. Collection agencies are governed by the Fair Debt Collection Practices Act, as are the debt buyers. Anyone who's trying to reach out to you to collect on a debt, they're covered by federal law as to what they can and can't do in order to keep them from making threats, threatening to call the cops on you, making false claims that they're associated with law enforcement. These types of things are usually scams. Creditors know better. But they can be very annoying, they can be very insistent, and they're not supposed to call outside of the hours of 8 a.m. to 9 p.m. They can call on holidays, but it does border on harassment. There are guidelines that are set to keep them from doing that. But once it's turned over to them, you have to determine whether or not the collector or the debt buyer actually has authority to deal on that debt. Sometimes you wind up making a payment or making an agreement with a debt collector, and then the debt's been sold to another party, and now your payment's in limbo and somebody's collecting on the entire debt. Well, you've already made a payment and you didn't get credit for it. So anytime you're dealing with a collector, make sure it's in writing. The Fair Debt Collection Practices Act requires them to let you know that you can dispute this and actually have them send verification in the mail. Now that request has to be made in writing. Most people don't know that and don't do that. But once it's been verified, you can actually set up a payment arrangement with them, but make sure it's in writing. If it's not in writing and the debt is sold, you don't have any proof that that arrangement was made. And unfortunately, over the years, I've gone and gotten judgments against a lot of people who have made verbal arrangements with companies, and the debt was sold after they made the arrangement, and they don't know where their payment went. And that does include these debt consolidation services, because some creditors just have a rule. We're not going to talk to anybody about your debt except you. And that's the way it's supposed to be. They're not supposed to be talking to the members of your family about this, except to find out where you are and how to get in touch with you about it. So when you're dealing with the original collector, that's your best bet. Make payments as best you can. A lot of times they will not verbally agree to take less than the full amount, but they're not going to reject money. If you send them a check, even a partial payment, they usually won't reject it. But if you get to a debt collector, reach out to a firm like ours and have somebody to represent you to talk to them. You have to have a written authorization to be able to do that. But if we get something in writing, then if they don't honor it, we can go back against that and say, okay, this is the agreement that we made. This is how we enforce it. So that's the protection I would say is out there available to consumers.
So what happens, Russ, if they're calling me at work and I tell them they can't call me at work anymore?
Honestly, the only way you can keep them from contacting whatever phone number that they have on file for you is to let them know you're represented by an attorney. Then they're not allowed to contact you anymore. They have to call your attorney. And that's the phrase I teach all of my clients. When they call, don't call me, call my attorney. Click. Make them call us. That's why we get paid, is to deal with these guys. If someone can withstand all the crazy calls and harassment and make it through onto the other side, more power to them. But if we can deal with them and make an arrangement for you and put it in writing where it's enforceable, that's great. But they are not supposed to be calling employers except to get in touch with and get good contact information for you. It's not supposed to be a collection call. They're not supposed to be telling your employer about your debts and your problems and your failure to pay your bills. That's a violation. You can sue under the Fair Debt Collection Practices Act for violations, but unless you have actual damages, your statutory damages are $100 to maybe $1,000, and you've got to go to federal court to get it. So that's not something you can necessarily go and stop them with, but if it's a pattern in practice, talk to us. We might be able to put a stop to it.
I think one thing to know as a person who's done credit advocacy before is that even if you try to settle a debt on your own, definitely have it in writing. But another factor that you want in writing is if they agree to correct or remove anything on your credit report, it has to be in writing, because you can pay that bill off or even do a settlement, but they can reflect that still negatively on your credit unless you have something of them guaranteeing that they're going to correct it and make your credit better. So I think that's an important lesson to everyone, because we all like to call and try to make arrangements to say, hey, if I settle this, will you quit reporting it negatively? And of course they agree because they want their money, right, but they're under no obligation to number one, go back and, correct anything as they already reported late payments. They don't have to do that. But number two is, like I said, if you settle with them, they can report it as, hey, this account was settled, not paid in full, and that still reflects negatively on your credit, even though you worked with them and did all that hard work to try to have a good faith of paying it off.
And you brought up a good point, Shauna. One thing is you should regularly pull and look at your own credit report. One thing that'll help you do is notice if somebody's maybe stolen your identity, or there's debts out there that are on there that shouldn't be. Right. So you can dispute those through the credit bureaus, and you do that in writing. You can find any of those addresses online. Just TransUnion and any of the credit bureaus have those online for you to dispute that. The other thing is keep in mind that a debt collector may be calling you on one of those debts, and they're doing the right thing because it's on your credit report, and you can't get angry at them. You have to figure out how that got there. If it's not your debt, you have to start taking steps to resolve that as soon as possible. And that's another thing that we can help with if you need that help. But always, especially in a new year, it doesn't hurt to pull your credit report. Most places you can pull it for free. I think one time a year there's some kind of minimums, but
and even credit cards and banks nowadays offer some kind of credit monitoring service for free, where you can look at your credit at any day. They usually do update it on a continually daily basis. So if you have a bank or a credit card, check with those unions to see if they offer the free credit monitoring service, and stay on top of it that way, because the more you know about your credit and stay on top of it, the better you're going to be in the long run.
And there's a difference between a credit report versus a credit score.
Yes.
Typically, your credit score is something that is a product that is purchased from a company. Your credit report can be obtained directly from there is a government website. You're able to obtain a copy of your credit report from all three of the credit reporting agencies. It's not going to have a score, but it will have the report of all the creditors on there. You can do that once for free every 6 months.
And you can dispute items on your credit through that website as well.
Absolutely. Every credit report that's given has a serial number on it. So within a certain time frame after you've gotten your credit report, you can actually dispute any of the entries, and we can help you with that if need be, for sure.
Cool. Okay, well, let's talk about when you have a debt and you can't come to a resolution or can't pay it off, and the debt collector ends up filing a lawsuit. Let's discuss what happens at that point and how that plays out.
I'll start here. First, if you get served with a lawsuit, do not ignore it. It's not just going to go away. Make sure you have a certain amount of time. If it's in a circuit court, you have 30 days to respond from date of service with an answer. So if you're going to deny this debt or this lawsuit and say, hey, I don't owe this, what's going on? If you do nothing because you think, well, I don't know, it's not a big deal. What's going to happen is when you don't answer that lawsuit, the creditor is going to file for what's called a default judgment. It means you didn't respond in the time allotted by law, so by right they have a system in place where they can file for what's called a default judgment, which means they're going to get a judgment against you, and at that point they can take all collection steps necessary to collect that judgment. And also with that, be very careful, because these judgments can be quite large and include more than your debt depending on the situation. And also interest, 7.5% interest annually by law they can charge till they collect that judgment. They can put liens on your home, liens on your bank accounts, all kinds of things. So do not ignore these. Consult an attorney right away after service. Don't wait till the 29th day and call an attorney and say, hey, this is due tomorrow. You're tying our hands. Not that you would, but take those things serious. Also, there's things that you can get in the mail that look similar. People make them look like you're possibly being sued. Don't risk that. If you have a question on it, go see an attorney and find out, is this legit? But typically on a debt like that, it's going to be personal service. Somebody's going to hand deliver it to you. Don't ignore it.
And we get calls a lot of times from people who say they received a letter. I got a letter in the mail. What do I need to do with this letter? Or I got a letter a couple of months ago about this debt. What do I need to do with that? Well, that was a lawsuit. We needed to have answered that. But once a suit has been filed, you actually have some structures in place through the court system to be able to defend your rights. The court doesn't want to enter a judgment against you without having given you an opportunity to give your case. So we have ways that we can fight. We have ways that we can go in and attack what they are trying to get a lawsuit or a judgment for. But even if we don't have factual or legal grounds to fight their claim, there are ways we can settle these as well. And typically the way they like to do that is, if you wanted to pay less than the full amount that was owed to them. Look, I know this is my debt. I just can't pay it. And that's why they filed suit, is I couldn't make the payments. Well, I want to pay less than the full amount. That's fine, but they're going to want to take it in a lump sum. The other way they like to handle these is, okay, you want to make a monthly payment on it, that's fine, but we're going to go ahead and enter a judgment now. We just won't garnish your wages. We won't garnish your bank account as long as you're making payments. But they want it paid within 2 years. So sometimes that's not even feasible. So we have to look at some of those options as well. But once it's filed, we actually are dealing with a law firm, whether they're in state or not. They're licensed in the state of Alabama if they file their suit here. And attorneys are held to a little bit higher standard, and as to what they can represent, what they can't do, what they can't through the court system. So you have a little bit more protection than when it's floating around out there to collectors, and it gives us an opportunity to have a conversation with one point of contact. It's not usually going to get transferred at that point, although I've seen it happen. But we can actually make some arrangements for you at that point that are going to help you out.
Yeah, a lot of times we can negotiate down those debts, and we can negotiate where we come to an agreement where there's not a judgment at times, so that you don't have that judgment that judgment's going to end up on your credit report. There's nothing we can do once a judgment is granted. It's going to end up on your credit report at some point. So, because it's public record, so make sure, again, you protect your rights. We're there to help you through that. We can dispute it. If it's absolutely not your debt, then we fight it. We can try to negotiate it so it doesn't end up, as a judgment lien on your credit or a lien on your home. But there's several ways we can go about this, and what we try to do is we try to streamline it. As a law firm, our goal is to streamline it and get it done as quickly and easily as possible, so you're not spending a ton of money to end up with the same result after going to trial.
Right.
So be aware of that. There's a lot of things we can do. Once another attorney is involved, we can negotiate on your behalf through that attorney and get these things settled a lot of times without a lot of expense. There's going to be some expense. That's just the nature of the game. Once a lawsuit's filed, you've got to defend your rights. Yeah. Even if you know you owe the debt, see an attorney. Don't wait, so that we can help. And there may be other avenues, as far as bankruptcy is another avenue that
That's the alternative. Let's talk about that. So if you have debt and you don't want to necessarily let it go so far to have a lawsuit filed, you just need that hard reset in life that we call bankruptcy. What does that look like, and does that even stop the collection calls once you file for bankruptcy?
It does. When you file bankruptcy, the federal law has an automatic stay of any collection proceedings that goes into place as soon as you file. They might not get notice of it right away. I tell my clients to give a couple of weeks for them to get notice and process it. If you start getting calls and you're getting letters more than 2 weeks after filing bankruptcy, okay, we need to do something and have them stopped. But until that point, they're going to continue to call and harass, but when you file a bankruptcy, the automatic stay goes into place. They cannot file lawsuits and they cannot continue with their lawsuits other than types of cases like for domestic support obligations and divorce cases. There are certain exceptions to that rule that can continue. But the basic consumer debt actions are stopped, or at least stayed. If you've had a bankruptcy that has been dismissed within a year prior to us filing for you, well, that bankruptcy stay only stays in place for 30 days unless we extend it. But it does give you pause to be able to find out what we can do. And if we're filing a Chapter 7 or a Chapter 13, either way, we're going to be able to deal with those debts in such a way that you're not going to have to deal with them outside of the protection of the bankruptcy court. So we'd be able to get you some breathing room to be able to deal with them for sure.
Russ, you mentioned Chapter 7 and Chapter 13. I'm sure people in the audience are going, what does that even mean?
Okay.
So, what does that even mean? What's the difference?
Besides bad numbers.
You're right, besides bad numbers, exactly. A Chapter 7 is what's called a liquidation plan. So if you have a Chapter 7, you have to qualify based on income, and they look at your assets, and anything that is not exempt under Alabama law is subject to being sold to pay off your debts. But you have to qualify for that. That whole process doesn't take more than about 6 months unless you have some debts that need to be, or some assets that need to be sold to pay the debts, and that may take a little bit longer. But that's what a liquidation is. There are no payments. It's not a 3 to 5 year repayment plan. It's a liquidation process. Now, Chapter 13, if you get to file a Chapter 13, if you get to file a 13, that's because you probably either have assets that are not exempt under Alabama law, or your income is to the point where you don't qualify for a Chapter 7. But a Chapter 13 is a 3 to 5 year repayment plan. It's called reorganization. You wind up setting a structure. Everybody files a claim, and we set a structure for your repayment. That can be difficult because you have typically different types of debts that you're going to have to pay during a very specific time frame, and your budget's going to be very, very specific. It can be very tight, and bankruptcy is intended to be. But it's one of those things that we try to make it as possible for you to make it through to your discharge, and so does the court, so does the trustee. Everybody's in this process to make sure that all the I's are dotted and T's are crossed to protect you so that you can pay off your debts to the extent possible in that plan and receive a discharge at the end so that you're protected from the collection processes we've been talking about.
All right, well, it sounds like the biggest factor is the income, you said, between Chapter 7 and 13, the income factor, and
that's the primary feature that is looked at.
Good to know.
Is your income. If you make too much money, you don't qualify for Chapter 7, we need to look at a Chapter 13. If you have assets that you just can't get rid of fast enough in order to be able to sell them and pay off your debt, then we look at a Chapter 7, and the trustee will work with you to take that asset, sell it to pay off the debt. Okay. Absolutely.
Well, I'm going to follow up with a couple of
I'm sorry, Shauna.
Oh, go ahead. I'm sorry.
I'm walking all over you today, talking out of turn. Real quick, bankruptcies, a lot of times you get in a situation where you've had no control, and you might have had a long hospital stay or unemployment or something like that. It's nothing to be ashamed of. People ask, well, bankruptcy is going to end up on my credit. In reality, folks, if you're in that situation and you're way behind on your bills, that stuff's already hit your credit report, and the only way to fix it a lot of times is to go through this process. It should be a last resort, though. If there's a way to help repay and do those things that you can do to get out of that debt, that's going to look better in the long run. But a lot of times these situations are out of our control. You know, you hear of people going into large consumer debt. Now, that's kind of not out of our control, but What we don't always know is the underlying reason for those things, like they're using credit cards to pay their bills because they are unemployed, or they're using credit cards to pay their bills because they were hospitalized for a long stay. So don't let pride get in your way. A lot of times these things are out of your control. You can get help. Come see us. Come talk to us. It's nothing to be ashamed of if you've been in those situations, and life happens. So, you know, we would prefer you come talk to us and let us move forward and help you get out of that situation in a legal way.
And can I mention one other thing? Since we are in Huntsville and so many people work on Redstone Arsenal, this is something that is dealt with a lot of times from a security point of view. We have a lot of innovation in this city, in this county, in this state. And a lot of people work in jobs that have security clearances, and security clearances sometimes are affected by debt and sometimes by bankruptcy. So that's something you may wind up needing to talk to your security officer about how it may affect your job. Most of the time it will not. If it's been because you've been hospitalized, if it's because of a divorce, something like that, it will not necessarily negatively affect, but it is a conversation that needs to be had with a security officer.
Okay. Thank you. Thank you for adding that on. We have a couple of minutes left, and I think we covered most of our questions that we had submitted by you guys for this episode. Just to wrap up, one, it's regarding bankruptcy and if it's going to be on your credit forever. The answer is no. The bankruptcy will fall off of your credit. And Russ, you can validate. You've seen people many times fix their credit, you know, before it was 7 years, is it?
10 years.
10 years. 10 years for bankruptcy to fall off.
But you can repair.
So it's not going to ruin your credit forever, but it's definitely it will take a hit to your credit.
Yeah.
But again, thank you guys for submitting your questions. We're glad to answer them on air. Please send them to legalhelp@jmmtlawfirm.com if you have any other questions for us.
Well, one thing to note on that is that when it does hit your credit report and all that, man, I lost my train of thought here. It's Sunday morning. Sorry about this.
Right.
That, you know, you will get companies that will help you rebuild your credit. You're going to get all kinds of things in the mail after that bankruptcy is over to help rebuild your credit. And if you use that properly, that's exactly a tool you can use and rebuild your credit faster. So, yeah, you're going to take a hit either way. If you stay in debt, you're going to take a hit. If you go bankruptcy, you're going to take a hit. So you have to decide how quickly you want to get your life back in order and go talk to somebody that can help. Come see us. Absolutely. Sorry about that, Sean.
No, it's good. It's good advice. So we want to definitely provide to our listeners out there. We want to keep them on the best path possible. Again, if you have more questions, send them to us. We'll be happy to answer them on air. Otherwise, we will see you guys next Sunday. I hope you have a great week. Thank you.
Bye-bye.
Bye-bye.